that in light of the developments since the committee's most recent meeting, including a federal court ruling, which found that the government's use of the Emergencies Act to have been illegal, and that the special criminal laws subsequently created by the Liberal cabinet to have been unconstitutional, to be an unconstitutional breach of Canadians' charter rights, as well as correspondence from the Privy Council office concerning translation of the evidence before the Public Order Emergency Commission. A, in relation to the federal court judgment, the committee invite the following witnesses to appear separately for at least 1 hour each. A, the Honourable David Lametti, the Minister of Justice and Attorney General of Canada at the time. B, the Honourable Arif Virani, the Minister of Justice and Attorney General of Canada. C, the Honourable Marco Mendicino, the Minister of Public Safety at the time. D, the Honourable Chrystia Freeland, the Deputy Prime Minister and Minister of Finance. E, Royal Canadian Mounted Police Superintendent Dennis Benoit. F, representatives of the Canadian Civil Liberties Association. G, representatives of the Canadian Constitutional Foundation. And H, other witnesses whose names are provided to the joint clerks by members of the committee within 10 days. And 2, an order to issue for all legal opinions which the government relied upon in determining that A, the threshold of threats to the security of Canada is defined by Section 2 of the Canadian Security Intelligence Act, required by Section 16 of the Emergencies Act, had been met. B, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. C, the situation could not be effectively dealt with under any other law in Canada as required by Section 3 of the Emergencies Act. D, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And E, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act, provided that these documents shall be deposited with the joint clerks without redaction and in both official languages within 10 days of the adoption of this order. B, in relation to the translation of commission evidence, the committee invite the following witnesses to appear separately for at least 1 hour each. A, senior officials from the Privy Council office, and B, other witnesses representing parties which placed unilingual submissions before the Commission or entities whose unilingual evidence was before the Commission, whose names are provided to the joint clerks by members of the committee within 10 days, and 2, members of the committee shall, within 10 days, identify their preliminary lists of unilingual Commission evidence or submissions for priority translation to the joint clerks who, in turn, shall relay those requests to the Privy Council office. C, to accommodate the scheduling of witnesses, the committee meet during the weeks of March 4 and 11, 2024, if necessary, and 2, if the number of witnesses proposed under clauses A, 1H, and B1B warrant, the joint chairs shall convene a meeting to discuss prioritizing their respective scheduling. And D, in relation to the committee's draft report, the committee suspend its work on the current draft report. The analysts be directed to prepare a second draft report, incorporating the information and analysis set out in the federal court ruling, along with the evidence received under paragraphs A and B. 3, members of the committee may, after the committee has received evidence under paragraphs A and B, submit draft recommendations and conclusions for the draft report, including those which may have been negated by the committee on May 16th and June 6th, 2023, where reconsideration may be warranted in light of the federal court judgment or the evidence received. And 4, the committee work toward a goal of tabling its final report by June 21, 2024. So, Chair, this is a very comprehensive motion. It covers off a number of things, and I believe very succinctly identify some of the areas where we want to go, or I think the committee needs to go in preparation for a fulsome study of and a conclusion to this particular event of the invocation of the Emergencies Act. Now, if we look at the reason why we're here and in following along with the purpose behind our committee, the Mosley decision is exactly some of the areas where we need to cover off. Was this legal? Did they follow the rules of law? Was it charter compliant? Those are all things that we need to examine as a committee. And just for everyone's reference, the federal court, I think, provided a very succinct review. I particularly was pleased with how well it was presented and provided clarity on not just he made a decision, but he provided the rationale for the decisions. And I think they were very, very sound. And I want to take just a moment to just refresh our memory on what those decisions were. So on January the 23rd, the Honorable Justice Mosley of the Federal Court issued his decision. So 4 groups applied for judicial review of the decision by the Governor General and Council to declare a public order emergency under the Emergencies Act. The February 14th, 2022 proclamation declaring a public order emergency and the enactment of temporary special measures in order to deal with protests in various parts of the country, which included the occupation of the downtown core of Ottawa and blockades of ports of entry, were under review. This was the first time that the act was invoked since its enactment in 1988. The proclamation, the emergency measures regulations, and the emergency economic measures order adopted under the act had a threefold impact. A, they prohibited a range of activities relating to protests in designated areas. B, they required third parties to assist the police in ending the protests. And C, they authorized financial institutions to disclose information on designated persons and entities to federal officials to suspend their accounts. The applicants and parties raised issues which led to the following questions. 1, was the proclamation unreasonable? With respect to the first question, the court considered the decision under the reasonableness standard of review and concluded that the answer was yes. The proclamation was unreasonable and illegal, ultra vires, which is really a term that means to act beyond one's authority or power. While the court recognized the occupation of downtown Ottawa and the blockades of the ports of entry were matters of serious concern, calling for government and police action, the threshold of national emergency required by the Act was not met. Under paragraph 3A of the Act, a national emergency is an urgent and critical situation that exceeds the capacity or authority of the provinces to deal with it, and that cannot be effectively dealt with under any other law in Canada. The proclamation applied the temporary special measures in all of Canada, in all of Canada's provinces and territories, despite the lack of evidence that it was necessary. Apart from the situation in Ottawa, the police were able to enforce the rule of law by applying the criminal code and other legislation. While the conclusion of the proclamation was illegal, it was sufficient to dispose of applications. The court addressed the other issues should it be found to have erred in its finding on the first question. The court considered the threshold for threats to the security of Canada. Section 2C of the Canadian Security Intelligence Services Act defines threats to the security of Canada as activities directed towards or in support of the threat or use of acts of serious violence against persons or property for the purpose of achieving a political, religious, or ideological objective. Under Section 17 of the Emergencies Act, the Governor and Council required reasonable grounds to believe that the standards set out in Section 2 of the CSIS Act had been met. The evidence in the record before the court did not support a finding that the impunged activities reached that threshold. The second question that was asked, did the powers created by the regulation and economic order violates sections 2B, C, D, or 7 or 8 of the Canadian Charter of Rights and Freedoms? And if so, could they be saved under Section 1 of the Charter? Now, concerning the Charter, the court found that the regulations infringed the guarantee of freedom of expression under Section 2B, as they were overbroad in their application to persons who wished to protest but were not engaged in activities likely to lead to a breach of the peace. The economic order infringed Section 8 of the Charter by permitting unreasonable search and seizure of the financial information of designated persons and the freezing of their bank and credit card accounts. The infringement of Section 2B and 8 of the Charter were found to be not minimally impairing, and could not therefore be justified under Section 1 of the Charter. The court found that there was no infringement of the rights to freedom of assembly, and so that particular piece of the Charter was not found to be a breach. Now, I think it's important to recognize that while Justice Rouleau had a role to play in his presentation of the evidence, we don't have a lot of the 250,000 documents that he said he saw. We're never going to see all of them, but he relied on, 7,000 documents to write his report. And so I think it's important that we, for some of the words that he used in his justification for his decision, Rouleau, to support the government's invocation was the evidence was underwhelming, and that any other person presented with the same evidence could reach a completely different conclusion. So it didn't leave me with a lot of confidence back in the day, and I've spoken that at this committee, that his decision did not leave me confidence. On the other hand, Justice Mosley's decision from a high court in this country has provided to me confirmation that there was an appropriate judicial review of the act and the use of the act, that it was found to be illegal in this circumstance, and that there was a breach of the Charter. So it begs a number of questions. Our role as a committee is to do a number of things. One of the things that Mr. Beattie, our very first witness of this committee, told us, he said, we need to ensure that the act is, our role is to look at the act and ensure that it is adjusted to ensure that no other government can present or invoke the Emergencies Act under the exact same circumstances again. And beyond that, we have asked for charter documents, a charter analysis that we never got. It was a trust us, we've done it, never did see it. And the other thing that Justice Rouleau made a comment about, that it was unfortunate the government chose to keep their broader interpretation to themselves. And Mosley speaks about that a number of times in his decision, that we're just supposed to trust them. Well, you know what? The Canadian public has lost trust with this decision. And so the motion has a number of different components to it that speak to the need to have certain people here as witnesses, the need to have documents. Again, this is not a new phenomenon for this committee. We've asked for documents that the government relied upon to make their invocation, and we haven't got them. In fact, it's quite telling that the government has refused at all levels to prevent some of this documents to be released, and I think it's unfortunate. The other issue that is before us and was left over from our meetings in the fall was the issue of translation. I don't know how we're going to solve that completely. I think we need to come to my personal opinion is we need to come to some compromise on how to make that work and make it work fairly for everyone. And I'm certainly open to conversations about what that might look like. But again, the motion as presented deals with the report as well, and where we need to go with the report, and the information we need to include in the report now moving forward, and the goal, with a goal to correct it. I think our longest, as I look forward to our calendar, I think the longest task that we're going to have is developing recommendations that are going to address some of the gaps in the current legislation that we might be able to fix. And we can do that, hopefully, a lot of it as a committee, and then have a report done. And if there's dissenting reports, then those, there's time to get those in as well. I certainly I'm open to debate on this, and I will acquiesce my time to the next speaker, Chair.
Merci, Monsieur.
Thank you, Mr. Motz. On my list, Ms. Romanado, Mr. Brock, and Senator Carignan. Ms. Romanado, the floor is yours. Thank you very much, Chair. I very much appreciate the explanations given by my colleague.
The committee, and so I too want to see if we can find a path forward, and that is why I had brought forward a motion that I think captures the two issues that are at hand, one of which is the importance of documents being translated in both official languages, and the other, obviously, our colleagues have a great interest in terms of the Mosley decision, which is why I put forward the suggestion to have the two ministers who are responsible brought forward to come and testify here before the committee. So in those aspects, I am in support of the way path forward, I think. I was not involved in this committee and the incredible work that you've done and the meetings that you've had. I have read the documentation from all of the meetings that happened prior, and I did read the draft report that you're working on. And I think if the goal is for this committee to do the work that we were mandated to do, based on the legislation that actually created this committee, Canadians are expecting us to submit that final report, and I believe we are there. I don't believe that we need to revisit having all of the same witnesses come back, based on the fact that a court has found with the Mosley decision something that the Conservatives were of course in support of. So I brought forward a compromise in terms of bringing a path forward and opening that conversation on how can we, between now, we have, I think, 12 meetings scheduled between now and June. How can the committee find a path forward in terms of addressing the question of translation and addressing the question of, okay, while outside of the scope of the mandate of this committee with respect to the Mosley decision, how do we get further explanation? And I think that's the will of the opposition to hear from the two ministers who are involved, and that is why I put a good faith motion forward. So I'm hopeful that we can come to some common ground here and move forward in a positive way so that we can issue that final report. Merci.
Merci, Madame Romanado.
Thank you, Ms. Romanado. On my list, Mr. Brock, Mr. Carignan, Ms. Mosley. Go ahead, Mr. Brock. The floor is yours.
No. Monsieur,
End up too on the screen.
pardon me. Oui, c'est le dernier que j'ai.
Yes, you will be the last. And I'm going to ask Mr. Senator Harper.
Thank you, Chair. And welcome to Ms. Romanado, Mr. Maloney. Welcome to our committee. I know you're... Oh, and Senator Smith.
Yes.
Yes, welcome.
Sorry.
Although you're new, it may seem daunting in terms of the length of time we've all been hearing evidence and discussing these issues. These are important issues. So some of the takeaways that I want to highlight first, I certainly will try not to repeat the comments of my colleague, Mr. Motz, but we are also desirous of coming to a conclusion sooner than later. And I believe there is a path forward to do that by the end of this session, sometime in June. But we never anticipated that when this particular committee began its examination of the invocation of the act and the circumstances surrounding it. While we heard rumors that there might be a charter challenge, we didn't know to what extent that would look like. We didn't know what the results would be. But we certainly had that at the back of our minds moving forward. And I also want to highlight on the issue of witnesses. Back in December of 2022, with a tie vote, and in this particular committee, a tie vote results in a negative passing of a particular motion, and a motion was brought by the Conservative team to extend the study, to call further witnesses that we deemed would provide relevant information, and the vote was 5-5. So by no means did that vote indicate a strong majority preference, in my view, to shut down the possibility of hearing from further witnesses. We lived by that decision, and we then instructed the analysts to prepare a review of the material and provide us with draft reports. We are now in draft version number 3. In that time frame, we had the Rouleau Commission, and I want to highlight that there's, although it's statutorily mandated that a commission launch during the invocation of an act or following the invocation of the Emergencies Act, and although it was presided by a justice, a Superior Court justice, the mandate of Justice Rouleau was not to provide any charter analysis of the legality behind the invocation of the act. That legal mandate did not exist. And I think in his wisdom, Justice Rouleau definitely shied away from making legal pronouncements because he knew ultimately this was a matter that was going to be studied and argued in the federal court. At that point, 2 institutions, as outlined in our particular motion, had launched a charter challenge, that being the Canadian Civil Liberties Association and the Canadian Constitution Foundation. So Justice Rouleau, as my colleague has indicated in his opening remarks and in the report itself, makes it abundantly clear that the evidence was by no means overwhelming to him to conclude that there was a legal justification by the Liberal government in invoking the act with the circumstances that presented itself primarily in downtown Ottawa and secondarily with respect to some of the border crossings in Alberta and here in Ontario at Windsor. He made it clear that reasonable people who had the ability to review all the evidence that he heard could come to a completely different conclusion than he did. And I highlight that phrase, evidence. And this segues to the concern that our Francophone members have on this committee, that the submissions and the evidence heard at the Rouleau Commission was not translated in the other official language, which has compromised the constitutional right that all members have in this House and in the Senate to receive information in both official languages. Now, we are certainly not suggesting, and the motion was drafted in such a way that we don't want every single piece of material or submissions officially translated into the other official language. It would take years to do that, and I think we received a figure in terms of the cost analysis well over $300 million. And at one point, this committee said, well, you know, that sounds like a daunting task. And given the financial crisis that we have in this country and the affordability issues and many families, thousands of families, literally one paycheck away from insolvency, we have to be prudent stewards of the taxpayer money. So that, in my opinion, would not be a proper exercise of our authority. We talked about perhaps just getting translated the index, an index indicating how the arguments were presented so we can identify who said what, and maybe the index of the exhibits, 2,500 potential exhibits. But again, that price tag was $5 or $6 million, another extraordinary expense that cannot be justified under any circumstances. So the motion is drafted as such that we can hear from individuals to perhaps give us the answers that we seek without going through the expense. And I think I can't speak for my colleague and chair, Monsieur Fortin, but I can speak on behalf of Senator Carignan, and he's certainly on the speaking list, and I don't want to take away his submissions, but I think that was a reasonable compromise. So I appreciate, Ms. Romanado, your approach. I think we're not too far off in terms of where we both see a pathway to proceed with, but I think it's incumbent on us as parliamentarians and senators to give value to Canadians. This was an extraordinary time in this country during the pandemic and the response to the pandemic by the convoy and the supporters of the convoy that descended here in Ottawa. But I think it's a reminder to us all that we are a country of law. We are a country of order. And we don't interpret the laws to fit what we believe as a government, a narrative that's not supported and grounded by facts and not supported and grounded by the legislation. The legislation in the Emergencies Act was abundantly clear. It could not be more clearer that the definition of a national emergency is the same definition as defined under the CSIS Act. It did not say anywhere, or as other interpretations may be available, or as other circumstances may be available. The law was black and white. It wasn't gray. And that's what we expect. That's what we expect in this country. We, as drafters of legislation, use our best skills and resources to provide clarity with the law. Sometimes we get it right, sometimes we get it wrong, and courts and appeal courts and ultimately the Supreme Court of Canada will weigh in if we do get it wrong. But in this particular case, as my colleague Mr. Motz has indicated, we heard from Perrin Beatty, who was a cabinet minister, who was primarily the architect of the Emergencies Act. And as we all know, the Emergencies Act was designed to replace the War Measures Act, which has significant flaws in terms of trouncing on the civil liberties of Canadians. And there was a mandate to do better. It was a mandate that we would create the most strongest, the most powerful law available to a national government in times of true national emergencies. Now, through resources that may not be wholly available to this committee, I've certainly been privy to resources from the government itself that there was even a consideration of the invocation of the Emergencies Act at the outset of the pandemic. Frightening, disturbing on so many levels. Then we had evidence very early on from ministers such as Mendocino and Lametti, the most powerful legislator, lawyer in this country, jokingly opining with Mendocino on day 2 of the convoy, let's bring in the tanks. Appalling. It was a joke, but it was an appalling remark. I have defended, and I will defend with my last breath as a member of the Law Society of Ontario, the Charter of Rights and Freedoms. And while the Charter of Rights and Freedom is drafted in such a way that these are not absolute rights, they are enshrined rights, and they are valued rights. The right to freedom of expression, the right to peaceful assembly, the right to be secure against unreasonable search and seizure. All of which ultimately came to a head with this Liberal government when they determined that, notwithstanding that the City of Ottawa Police Service, as well as the City of Ottawa municipal government, directed the convoy truckers to park on Wellington Street, directed that there be a off-site location for the supply of materials to run back and forth. All of this was planned. It was organized. There was discussion between legal authorities and the truckers. One thing that no witness has ever been able to answer, and I asked this, if I asked it a half a dozen times, I probably asked it 24 times. At what point in time and at what event did this lawful exercise of the freedom of expression and assembly, as directed by legal authorities, become unlawful? No one could answer that. The only thing I could surmise is that it became inconvenient to the government. It was certainly inconvenient to citizens in downtown Ottawa. The smell of diesel, the noise, the commotion. But in Justice Mosley's words, that's not a national emergency. That's what protests are. Protests can be loud. They can be uncomfortable. They can be a nuisance. But it doesn't rise to the high legal threshold of a national emergency. Now, all I ever heard, as well as parliamentarians and Canadians, is that this was required, that lawful legal measures was simply incapable of dealing appropriately with the removal of this blockade. And there's contradictory evidence, and I'm not going to get into that. The evidence is already on the table on that issue. But more importantly, what we heard from the Prime Minister to Marco Mendocino and David Lametti and Minister Freeland and Minister Blair and probably the entire cabinet bench was, this was necessary, this was lawful, and we had legal justification. It was charter compliant. When we asked for evidence of charter compliance, oh, you can't have that. That's protected by cabinet confidentiality. Or you can't have that, Mr. Brock. That's protected by solicitor and client privilege. But the Prime Minister had no problems waiving privilege, had no problems waiving confidentiality with Justice Rouleau, save and except that legal opinion that they received from the Department of Justice, which would have laid out under what legal authority do you have as a Prime Minister in government to invoke that act. They would not share that, even to Justice Rouleau. And I remember this exchange because I watched it live and I read the transcript after we heard the in-chief testimony of David Lametti, former Justice Minister, and the cross-examination, as judges often do and are entitled to do. They question the witnesses. And Justice Rouleau did that. And Justice Rouleau, I'm not quoting word for word here, but essentially said, well, you're not going to give us the legal opinion that justified your use of the Invocation Act. Am I to take from that, I'm just simply have to accept your opinion that it provided you with the legal authority? And David Lametti said, yes, take my opinion. He could be right, but he also could be wrong. And I think it's important that we have access to that legal opinion, which is why we set it out in the notice of motion. And I think long term, because ultimately the government has telegraphed, like literally within minutes, telegraphed an intention to appeal Justice Mosley's decision, a very senior justice appointed by a Liberal Prime Minister, I might add, a very senior justice of the federal court. Other significant decisions that we have heard that impact the lives of Canadians, well, we're going to take it under advisement. We're going to examine all the circumstances behind the decision and weigh our options before we consider an appeal or not to appeal. But not this. Literally a jackrabbit response. He got it wrong. We heard that from our new Justice Minister. He committed judicial errors. I'm sure at that point our Justice Minister didn't even read the full decision. It was a very lengthy decision. And I would be surprised if he had the time to read the decision in full before he quickly pronounced all the judicial errors that Justice Mosley made in his decision. But this again was parroted by the Deputy Prime Minister and many other ministers. There are justifiable legal errors that we can appeal. Now, I'm saying this because ultimately, if they hold true to their word and they will appeal this decision, ultimately the appellate court, wherever that may be, the Federal Court of Appeal, maybe ultimately the Supreme Court of Canada, is ultimately going to hear from Department of Justice lawyers as to what the legal advice they gave to justify the invocation of the act. It's eventually going to come out. If it's going to come out eventually in this promised appeal, then let us share this with parliamentarians. Let us share this with committee members. Let us share this with Canadians, because they have a right to this information, as do we. So I've gone on long enough. I know other members want to talk, and I don't want to sit here till 9:30. So I'm going to cede my time back to the chair. Thank you very much.
Merci, Monsieur Brock.
Thank you, Mr. Brock. Senator Carignan, you have the floor. Thank you. I think it is wise to recall, especially for the newcomers who were not here, to recall what unfolded, especially September 22nd of 2022. We wanted to hear from witnesses, a number of witnesses, namely the Prime Minister, but certainly a number of witnesses. And the committee, in its wisdom, said that will double the work. If the witness will go before the Rouleau Commission, before House committees, let us resolve that all testimony that is presented before the Rouleau Commission or before the committee come before us, so that we can take that testimony into account. And I recall this because it's important. We know that we cannot examine all of the evidence put before the Rouleau Commission. So the idea is to just listen to some witnesses. We can't examine all of the Rouleau Commission evidence. Why can we not? Well, we asked that it be translated. At one point, we realized it hadn't not even been translated. And when I talk translation, I'm not talking about this as just a francophone. Even the French testimony is not translated into English. So you, as Anglophones, might say, well, I don't understand the French, but there's, French testimony, and I would be, embarrassed. So this problem applies both to Francophones and Anglophones. A good part of the documents, when tabled in English, are not translated in French, and when they're tabled in French, they're not translated into English. So we wrote, and we asked, could you, the Privy Council, please translate the documents? After several months, the PCO said, well, it's complicated, it's lengthy. Instead of telling us right from the start it would be long and complicated, we waited months, and then we wrote a letter from the chairs and say, when are you going to send us the translated documents? PCO took the time. And we learned just before Christmas that it was going to be very difficult task. So we then asked for an index so that we could then pinpoint which testimony wanted translated. We were told it would take a year just to get translated what's in the index, and the cost would be $300 million, and it would take years to translate all the evidence. So what do? The spirit from the outset was to listen to the witnesses. Then we cut back on the witnesses, say we're going to take the evidence put before the Rouleau Commission, but that was impossible to then do. And that is why I worked with my colleagues to identify a list of witnesses and of documents, a modus operandi, so that we could at least have the witnesses that we would not have had to bring in if we'd had the evidence put before the Rouleau Commission, but produce that evidence that we wanted, and then be able to come up with a framework with which we were comfortable. Now, at the end of the motion, well, my constitutional rights have been violated. It is absolutely certain that it's going to be a point of privilege for me at the Senate, because we cannot work as a committee without having heard from the witnesses and having had the documents in the two official languages. We need that. And with all due respect for our new colleague, I had a look at your motion, and it does not encompass the issue of translation. It just says we're going to, ask PCO to explain what's unfolded. Well, they've already told us. They will can come and tell us why it's going to cost $300 million. But then what do we do? How do we access the evidence? We need to bring in the witnesses, and we need to find a way to identify, minimally, those documents we deem important that need to be translated, to have them in the two official languages. Otherwise, we cannot do our work. It will be partial, and it will violate our constitutional rights. I believe that the motion we have tabled is a compromise. It allows us a modus operandi. Maybe there's a little bit of fine-tuning, a bit of a cleanup, or maybe a bit more clarity, but we do need this to be able to finish the report and to respect the spirit of the motion of September 22nd of 2022, where we said, we can't hear from all the witnesses. So we must find a way to proceed. It needs to be in the two official languages. And we know that in our parliamentary committees, everything needs to be done in the two official languages. And as to the Rulo Commission, well, I've already filed a complaint with the official language commissioner regarding the Rulo Commission, and I have another complaint in regard to the Privy Council. And so all with a view to this never, ever happening again in the future. But to do the work we need to do, we need the witnesses and we need the documents in the two official languages. And if there's any member here who does not understand French or, can't read in French, needs the translation, I think, it's a big shortcoming. Big shortcoming. Thank you.
Merci, Sénateur Carignan.
Thank you, Senator Carignan. Now the floor is Mr. Maloney.
Thank you, Chair. I'm also a new member to this committee, and I don't have the benefit of having sat through the many, many meetings or testimony was provided, and you discussed all these other issues. So I'm sometimes think that might be a useful perspective because I'm a fresh set of eyes. Although I'm sure some will disagree with me. Senator, I am one of those people who does not speak French, one of my many regrets in life. So I will need the benefit of translation, and I agree with you, sir, that we must do things and conduct ourselves in a bilingual fashion so that that resource is available to all. So thank you for pointing that out. But look, I'm going to address something Mr. Brock said. I mean, if I look at the Emergencies Act, what this committee is doing, it's meant to be a contemporaneous review of following the invocation of the Emergencies Act, not to review whether or not it was appropriate to invoke it, but to review the exercise of the powers and performance of its duties. And Mr. Motz said in his submissions that, the report needs to address gaps in the legislation. From what I've seen and read and heard, we're in a position to do that now. I mean, Mr. Brock, there's a certain amount of irony in my mind when he welcomes Ms. Romanado and myself and Senator Smith to the committee, combine that with their motion when you're bringing in all of these proposed witnesses under all sections of the motion, because it sort of flies in the face of the contemporaneous notion, because some of these people have retired, some of them people are now ministers, in fact, former members of this committee. If we proceed in the fashion that you are proposing in this motion, I suspect the three of us won't be the last new members who join this committee and have to get up to speed on this. Look, we have two issues at hand. One of them is the documents and dealing with the bilingual issue and getting them translated. I disagree with the senator's position again, because Ms. Romanado's motion does address that issue. We'll have people from the Privy Council who come in here. That does not foreclose having other witnesses, but it gets us to a place we need to be to understand why they are telling us what they're telling us in terms of costs and time and whatnot. I don't think anybody will agree that it's a good idea to spend all of those years waiting for translated documents. And if I look at this motion, it occurred to me as I was looking at it, subsection, it's B, big B, small 2, says one of the witnesses they're proposing to call are members of the committee shall within 10 days identify the preliminary list lists of unilingual commission evidence or submissions for priority translation to the clerks, who in turn shall relate. So if I read that correctly, what's being proposed is you bring in people who submitted documents in only one language, have those witnesses come here and testify to what end, I'm not quite sure, except that we want to make a decision based on that evidence to then decide which documents we want to translate. That seems a bit like chasing my tail, to be completely candid with you, and doesn't seem to be a productive exercise, because I don't think it'll get us any closer to getting those documents translated than when we're at right now. So my suggestion would be that we look closely at Ms. Romanato's motion, deal with the two issues at hand. And the other thing about this motion is, Mr. Brock talked about the Mosley decision and Justice Rouleau. I mean, I suppose I could sit here and pontificate about who was more senior at the bench and whose career was stronger and whose opinion I will put more weight on personally. But I don't think any of you would want to hear it, and it wouldn't be particularly useful or productive. But that's not our job either. We're not a court of appeal. We have a very specific task to do in a very limited time frame, and we're past that time frame. So I would, and the part of their motion suggests that this report that we're going to deal be done by June of 2024. It's not possible, because this appeal will not, it probably won't even be perfected by June of 2024, let alone decision. We're not, otherwise, why don't we just all agree that let's reconvene after these appeals are exhausted, whether it's the Federal Court of Appeal or the Supreme Court of Canada, and then we can review all of the evidence that was put before these. It's an absurd assertion, I realize, but that's sort of where we are. We have a job to do. I would suggest we take the information we have. We have the two witnesses proposed by Ms. Romanato who are going to address some components of the Mosley decision. I don't know that new evidence will be allowed on the appeal, Mr. Brock. I suppose somebody could argue that, but I don't think that's realistic to expect that there's going to be evidence put before an appeal court that wasn't heard at first instance. Well, there was a suggestion that some of the documentation with respect to the justification for the invocation might appear before the court. So they're going to have exactly the same documentary record and appeal that they did at first instance. So that won't offer any new insight. So my view is that we should move quickly, move to Ms. Romanato's motion, and deal with the two issues at hand, recognizing the time constraints we have and the physical constraints we have because of the documents. Thank you, Mr. Chair.
Monsieur.
Mr. Nakfi, you have the floor.
Thank you very much, Chair, and my apologies that I'm attending this meeting virtually given my parental duties. But I am one of the members, along with a few of the members who've been part of this committee from the get-go, and have sat through hours and hours of meetings and these similar conversations and witnesses and hearing their perspective on what happened. As I read the motion that is being tabled by Mr. Motz, I'm inclined to think this is an effort to have this committee act almost as de novo, just because of a decision from a court of first instance only. In my view, this motion is too broad. We have heard from most of these witnesses already that information is available to us to do our job. And just because we have one decision from a trial division level does not gives us enough reason to start all over again. Not to mention, as I'm hearing my colleagues speak, especially from the Conservative side, I'm again reminded that they're attempting to go beyond the scope of the legislation. And again, I remind members of this committee to look at Section 62, Sub 1 of the Emergencies Act that outlines very clearly as to what the scope of this parliamentary review is. And if, by Mr. Brock's assertion, if Justice Rouleau was not required under the Act to look at the issues of constitutionality, then I would suggest to you, if you look at the wording in Section 62, nor are we are asked to look at the constitutionality of the matter. We've got the Rouleau Commission before us, and we have that extensive report. We obviously have a decision by Federal Court Trial Division as well. I think what we need to focus on, and this is where I would suggest that we hear from Ms. Romanado and her motion, that I think it presents a far more credible path in terms of inviting both the Justice Minister and the Minister of Public Safety so that we can hear their perspective as to the Mosley decision, that we hear from the Privy Council to better understand the issues around translation, and collectively come up with a path that will allow us to bring this committee to a conclusion with a report that will serve the best interest of Canadians. I think it's quite obvious that we may have more than one report in this matter, just being part of this committee for 2 years now, almost 2 years, and hearing the views, and that's okay. I think that people are entitled to do so. But let's get to the point where we can share our perspective with Canadians, given the amount of work we've done. But keep going back in circles, starting anew is not going to serve that purpose, and I think we will be providing a disservice to Canadians. Thank you, Mr. Chair.
Merci, Monsieur Naqvi.
Thank you, Mr. Naqvi. Senator Harder.
I'm going to be relatively brief, even though the cameras are on. We're now almost entering our third year in this committee. It had been my hope for those of you who have joined subsequently that we would report before Rouleau finished his report. You realize how naive my wishes were, but I viewed the work of this committee as rather limited. And indeed, you could argue whether or not this committee should have been formed at all, but that's another matter worthy of debate. We are not an ongoing commentary of all of the actions taking place in other streams. Rouleau had his mandate. We've now had one trial division judge. We've still got a class action suit. Are we just going to continue to sit to pick out parts of whatever legal processes might be in place to reinforce our biases or our views? I don't think we're going to change views in our discussion, frankly. They haven't changed in 2 years, so I don't think that that's going to come. So I think we really have to figure out, do we want to finish or not? The motion before us, I oppose, because frankly, it's a motion purporting to bring conclusion, but will ensure conclusion never takes place. I would rather see us go forward in the spirit of what Member of Parliament Romado has suggested, to open it up, yes, for some additional witnesses, but we were so close to finishing our report and making our contribution, which isn't the last word by any means. On the issue of translation, I'm not sure I agree with my Senate colleague, as much as I respect him, that it is a constitutional right to have every document of every commission translated. The Privy Council office has said that the actions of the Rouleau in terms of translation was compliant with the Official Languages Act. That's our obligation to ensure. If there is other legal processes that will define whether or not that is adequate, God bless, go forward. But I think it's a tactical maneuver to prevent us from concluding. We have Rouleau's report, 900 pages. Are we really thinking, waiting 4 more years to have more translation will change anybody's mind or even be read? I don't think so. So I would urge colleagues to put aside the processes that we put forward to kind of pretend as though we're wanting to move forward when we're ragging the puck,
and get more ambitious about concluding this committee so that before we rise in the summer, we've made our contribution, because I think we adopt this motion, you can guarantee that we'll be meeting until the end of this Parliament.
Merci.
Thank you, Senator Harder. And now, Mr. Green, you have the floor.
Say I've certainly benefited from taking the time to listen to everybody's arguments. As you know, throughout this process, I've been fairly consistent on taking principal positions that I think are consistent with our party, and as a party that supported the invocation of the Act on its face value based on public information that was readily available. And while respecting the summary that was put in terms of the context, it seems that we always